presentation will be basically to introduce this booklet that was prepared by the CarIPI project in consultation with the TTIPO, with the purpose of making the Madrid Protocol better known in Trinidad and Tobago. And for those who are interested in protecting their brands abroad to know how better to use this system. We say the Madrid Protocol, it's a brand protection system that is available today to nationals of 124 states, including Trinidad and Tobago. It can be defined as a business competitiveness tool of special interest to export industries, and also as a trademark protection route that is increasingly being used by all types of companies, and particularly attractive for small and medium-sized companies. When we speak about the protocol, we are speaking about your brand. In fact, the brand is the image that differentiates you from your competitors. It conveys a sense of quality, of credibility, of customer satisfaction. It generates loyalty. It plays a crucial role in marketing strategies. It is at the core of business competitiveness, and it has a value. It may well become the strongest asset of a company, as is the case, well, for many of these companies that have trademarks as these ones that are Trinidadian trademarks. How to develop an effective branding strategy? Well, by creating an image in the consumer's minds through advertising campaigns, certainly, but also through ensuring the legal protection of the brand through trademark registration. And trademark registration in the country, but also abroad, because the mark is the legal expression of your brand. And how do you protect your brand in Trinidad and Tobago? Well, by having it registered at TTIPO, and in that way, you get an exclusive right on the commercial use of your mark for a period of 10 years, renewable for another 10 years indefinitely, and you can prevent third parties from using your mark or a similar sign to commercialize the same or similar goods or services in Trinidad and Tobago. But why is it necessary then to get protection abroad? Well, because of the territorial effect of trademark law, because a trademark is valid within the territory of the authority that has issued that right. And so if you wish to export goods or services with your mark and adding value to them, if you wish to prevent third parties from using your mark in foreign markets, if you wish to get a reputation abroad and gain new clients and generate new business opportunities, well, you need to get protection for your mark in each of the markets of interest to you. And how do you get your mark protected abroad? Well, a first way is to go country by country, requesting the registration of your mark at the national office of each country separately, and you will get a trademark right valid in that specific country. There are some countries that have joined together to form regional systems. For example, the 3 Benelux countries or 17 African states that have set up the African Intellectual Property Organization, or the 27 European states that conform the European Union. They all have a regional office. Each of them has a regional office issuing a trademark right that is valid in the territories of all their members. But then there's the international system, the Madrid Protocol, that was established in 1999 and is administered by the World Intellectual Property Organization. And this is a system that can be combined with the previous ones that I've just mentioned, as we will see. The Madrid Protocol has today 108 members, including as members the European Union and CarIPI. 108 members after the recent accession of Pakistan. It is available to nationals of 124 states, and including Trinidad and Tobago, which is a member since January 2021, it became effective, the accession of Trinidad and Tobago to the treaty. The coverage today of the Madrid Union is at present then, as shown in this map. And you see it's a wide coverage and represents, in a way, 80% of world trade. And among the countries that are parties to this system, they include very many trade partners of Trinidad and Tobago. If we consider, for example, the top export destinations for goods and services from the country in 2019, we can see that some 75% of exports by Trinidad and Tobago were to Madrid Union members, including the United States of America, European Union, China, but also many other Madrid Union members such as Brazil, Republic of Korea, Mexico, Canada, Israel, Morocco, Colombia, etc. A first question you may ask yourselves, are you entitled to use the Madrid system? Yes, if you comply with these two conditions. First of all, that you have an attachment to Trinidad and Tobago, and secondly, that you have a basic mark in the country. An attachment means nationality or domicile or industrial or commercial establishment in Trinidad and Tobago, and a basic mark means a trademark application or a trademark registration at TTIPO. We say that the Madrid Protocol is a business competitiveness tool that is of special interest to export industries because it allows you to obtain protection and maintain protection abroad, not in your country of origin. And it does so by facilitating protection in export markets by offering a very simple, expedite, and cost-effective set of procedures for entrepreneurs to apply for the legal protection of their brands in export markets. And this is what we call the central filing of trademark applications, but also, and very importantly, to manage their trademark rights valid in various countries. And this is what we call the central management of trademark registrations. Suppose that you're a company that wants to get protection in these 12 markets represented here by their flags, either countries or region in the case of the European Union. Well, if you go the traditional filing way, you have to submit a separate trademark application at the national or regional office of each of these countries or region. So this means separate applications, different languages, translation costs, fees paid in different local currencies, which imply currency exchange costs, local representative frequently required and additional costs involved, and different procedures from the very start with different time frames. It may become relatively cumbersome if you want to get protection in several countries. So let us compare this with the Madrid central filing. You want to get protection in this same group of market, and you can do so if you do it through the Madrid system by filing a single international application at the TTIPO. TTIPO will check it, will send it to WIPO. WIPO will check it as well. And if everything is okay, will register your international registration will then be published by WIPO and transmitted to each of the designated contracting parties. And it will be then for them to decide finally if your mark is granted protection in that jurisdiction or not. So here we have then a single application at TTIPO, a single language, English, fees paid in a single currency, which is Swiss francs. A local representative will be required, but only in limited cases. And you have a single international procedure going from the very beginning up to the registration by WIPO, and then strict deadlines for the rest for the procedure at the national or regional level in the designated contracting parties. So you see, Madrid central filing offers quite a number of advantages. But even more important are the advantages of Madrid central management. Suppose you have already, through the Madrid system, your mark protected in these 12 markets, but you will have to renew your rights every 10 years. And you will be able to do so by simply filing a renewal request with WIPO, which will simply transmit it to each of the designated contracting parties. And suppose that a few years later, 2 or 3 years later, you want to extend protection to other countries, to Japan, Singapore, and Antigua and Barbuda, for example. Well, the Madrid system offers you an interesting feature, which is called subsequent designation, whereby you can request WIPO to designate these 3 new countries, and WIPO will transmit your request to them, and they will decide whether they grant protection for your mark or not in their territories. Finally, there's the possibility to have some modifications to your international registration recorded by WIPO. a change of name or address, an assignment of rights, with effect in all the designated countries of interest to you. So you see, there are many advantages in the Madrid system, but let us go a little bit more in detail about what are the basic steps of central filing of your application. You will have to, first of all, choose the mark that you want to protect, which implies making a trademark search, then prepare your international application, then file it at TTIPO. Finally, monitoring your application up to registration by WIPO, and finally, monitoring acceptance of your registration in each of the designated contracting parties. Why making a trademark search? Well, to make sure that your mark is not already protected by someone else in the export markets of interest to you. And in this respect, there are some international search tools that are very useful, user-friendly, and that offer free of charge trademark data information to you. TMView, with more than 94 million trademarks from 75 trademark offices, and WIPO Global Brand, which contains more than 47 million entries from 67 collections. I recommend that you make a search in these tools before you prepare your international application. Once you get to preparing your international application, you will have to submit it in a special form, MM2 form in English, which can be downloaded from this web address. The guidebook offers you recommendations regarding how to fill in this form and what is the mandatory content, the optional content, the special requirements by certain designated contracting parties. I will only refer very briefly to each of them now. First of all, you will have to draw your list of goods and services, and you have to make sure that the goods and services in your international application are covered by the list in the basic mark that you have in Trinidad and Tobago, are not expressed in terms that are too vague or linguistically incorrect or incomprehensible, and that they are correctly classified according to the international classification. Now, the best practice is to use online classification tools, again, free of charge. TM Class, which contains terms accepted by 84 trademark offices from around the world, and very importantly, MGS. I recommend you very particularly that you use MGS before filing an international application because it contains terms that are accepted by WIPO. They are not going to be refused. WIPO is not going to issue any irregularity notice to you regarding classification if you use terms from MGS. And you will know as well whether they are accepted by Port Madrid Union offices. Then in your international application, we'll have to designate contracting parties, and you can designate up to 107 contracting parties by simply checking the box next to the name of each, including the European Union. The code for the European Union is EM and OAPI code OA. If you designate the United States, you must declare your intention to use the mark in the US by also filling in a separate form that is called MM18. And if you designate the European Union, you must indicate a second language, which has to be either French or German or Italian or Spanish, but it's a language that may be used, not necessarily, you may be using it in English, but it may be used if this is chosen by a third party in the case of opposition or cancellation procedures. When designating the EU, you may also claim seniority of an earlier mark in a separate form, an earlier European Union mark. Then you will have to calculate and pay your fees. You will have to pay a basic fee and a designation fee per each designated contracting party, which may be an individual or complementary fee, and a supplementary fee per each class beyond 3. But this is only if you designate contracting party that does not charge an individual fee. The best thing is to look at the fee calculator. Fee calculator is a very useful tool offered by WIPO. You calculate and you just input the countries where you want to get protection, the number of classes that you want to protect, and it calculates exactly how much you will have to pay. Just to give you an idea, in 2020, last year, the average fee was 3,392 Swiss francs for protection 2-3 classes in 7 designated contracting parties. But more than half of the applicants had to pay less than 2,400 Swiss francs. And the payment can be made by bank transfer or by current account if you have one at WIPO. Once you have your international application ready, you will file it at TTIPO, and TTIPO will check that you're the applicant or holder of the basic mark, that your mark is identical to the basic mark, and that the goods and services in your international application are covered by those in the basic mark. And if so, TTIPO will forward the international application to WIPO, indicating the date in which it was received by TTIPO, which may become the date of your international registration. WIPO will check if there are any irregularities, and if everything is okay, it will register your mark in the international register, will publish the international registration in the Gazette, will notify it to the designated contracting parties, will inform TTIPO, and will send you your international registration certificate. What will be the effects of your international registration? Well, your international registration will have the same effects as a national application or regional in all the designated Madrid Union members as from the date of the international registration, and as a national registration of a duration of 10 years in all those designated contracting parties, if they provide that they do not refuse protection within very strict time limits, which are 12 months or 18 months, or in some cases of opposition, slightly more than 18 months, and or that they have subsequently withdrawn their refusals. In such cases, you will get protection for 10 years in each of those designated contracting parties. WIPO offers you another very useful tool, which is called the Madrid Monitor. It's an online service enabling you to track the status of your international application at WIPO up to registration, and to have access to information on all marks registered through the Madrid system, to track the fate of your international registrations in the designated contracting parties, and to request an email alert anytime a trademark record is updated. As I mentioned to you earlier, not only filing international applications becomes easier, but also the central management of your registration. And in this respect, the Madrid system also offers you another tool, which is called Madrid Portfolio Manager. Once you have an international registration, you can create your own portfolio, and then you can upload requests for renewal of your mark, for subsequent designation, and for recording various types of changes at WIPO. Your Madrid Portfolio Manager is available at the WIPO IP portal. And to access it, you need to have a WIPO user account that you can create very easily and free of charge at this web address. Then you will be able to renew your mark every 10 years through the portal, and you will have to pay your fees, and you will know how much to pay, taking into account the fee calculator. Payment can be made by bank transfer and current account, or in this case, also by credit card. If you want to submit a subsequent designation because you're the holder already of a trademark that is valid, as supposing in these 5 markets, and you wish to extend protection for 3 new countries, let us say these 3 countries represented here, you can submit a subsequent designation to WIPO, and WIPO will inform these countries, which will decide finally if they grant protection to your mark. And you can do so online through the WIPO IP portal. You will have to pay some fees. You can calculate the fees with a fee calculator. You can pay them through bank transfer again, current account or credit card. And the effects will be, if they're not refused, your mark will be protected in those countries for the remaining duration of your international registration, and they will be renewable for further periods of 10 years. Finally, some recording of certain modifications can be made, a change in ownership, a change of name or address of the holder, or the recording of a license with effects in all or some of the designated contracting parties. Before concluding, just let me say a few words about this feature, which is a particular feature of the system, and that is that for a period of 5 years from the date of your international registration, the fate of your international registration will depend on the fate of your basic mark in Trinidad and Tobago. So if for whatever reason your basic mark in Trinidad and Tobago ceases to have effect because it's refused or it's canceled or it's invalidated, either totally or partially during this dependency period, your international registration will be canceled to the extent to which your basic mark has ceased to have effect. Now, This is a risk that you're running, but it is a relatively low risk, I would say. In fact, if we take into account the figures of how many ceasing of effects take place, in fact, I've looked at the last 4 or 5 years, and less than 4% of international registrations have been cancelled because the basic mark has ceased to have effect. But the system also offers you an alternative if this happens, that your international registration is cancelled, and that is, it gives you the right to file a trademark application based on your international registration in any of the designated contracting parties during a period of 3 months after cancellation. And that application will enjoy the priority of your international registration. So to conclude, let me just summarize a few of the advantages of this system. It is a user-friendly system, expeditious route to acquire and manage your trademark rights abroad. It offers you considerable savings in translation costs through local representation or the costs like currency exchanges. It's a valuable help to export goods and services with your brand, adding value to your exports, and to gain early brand presence abroad, helping you to acquire global reputation and goodwill. And it opens you increased franchising and partnership opportunities and facilitates the possibility for you to integrate in global supply chains. So if we are to give a word of advice, I would encourage you to take advantage of the Madrid Protocol to protect your brands abroad. Thank you very much.
So I just want to quickly give you a practical example to further highlight those benefits, as well as give you some statistics on the possible impact of the Madrid system on Trinidad and Tobago so far. So let's start. So this is a fictional example prepared by WIPO to help illustrate some of the practical aspects of the Madrid system. So this is Sally, and Sally lives in Trinidad and she produces honey. So Sally knows that it's super important to have a trademark to distinguish her honey from other companies selling honey. And she has created a trademark, and you can see it here. It's a word mark by Sally with a distinctive, hopefully, device. She has protected this mark already in her home country, Trinidad and Tobago, but now she wishes to export her products abroad. So she's looking to protect her mark in Germany, Russia, and the United States and China. So Sally has 2 options. So she could file directly before the IP offices of the countries she wants protection in. So that will be China, Germany, Russia, and the USA. And this will be using the national route. She would need to instruct local attorneys in each of the countries concerned. She would also need to fill in 4 forms, file it in 4 languages, and pay her fees in 4 currencies. Now, hopefully, it will result in 4 registrations. But she will need to manage those registrations separately because they all have separate renewal dates. So it is possible to use this route, but it could be costly and it could get complicated. So the other option, as explained perfectly by Mr. Rubio, is the Madrid system. So she could file just 1 application through her home office, the TTIPO, and she can designate the countries of interest here, China, Germany, Russia, and the United States, using the 1 form, 1 language, 1 fee, and having 1 renewal date. So much easier to manage. As you can see, it's far more streamlined process. So just a quick cost on that example. So if Sally were to use the Madrid system, she would have to pay a basic fee. She'd have to pay her fees for the designated members. So in this example, she would need to pay for China, Germany, Russia, and the United States. So a mark, an international mark for these countries in color for 2 classes would come to a total of 2,397 Swiss francs. Now, if she were to go the national route, we won't have exact estimates for this, but she will not have to pay a basic fee, of course, but she will need to pay official fees in the 4 countries, and there will be additional costs. So these costs will be for translations and local attorney fees. Now, these can really mount up. So it could end up being quite a lot more expensive going the national route than going through the Madrid system. So now let's move on and have a look at the impact of the Madrid system, what it can do for Trinidad and Tobago in terms of business coming into the country. So it's of course a bit early to understand what the real impact will be, given that it's only been around 6 months, but early indications that there has been a slight decrease in direct filings from non-residents compared to last year during the same period, which could of course be down to the pandemic or some other reasons unrelated to the accession. There has already been a decent number of designations under the Madrid system, so resulting in an overall increase in filings in Trinidad and Tobago. In fact, Trinidad and Tobago has now received 274 designations coming through WIPO. Now, just over 130 have been inscribed, but we do have 140-ish still pending formality checks at WIPO. So this is just a bit of a heads up to the TTIPO. You may be a little bit busy in the coming weeks. Out of interest, the top 5 countries of these designations, so where they're coming from, where the holders are coming from, the United States, the United Kingdom, China, Korea, and the European Union. So Trinidad and Tobago's accession to the Madrid Protocol does not automatically mean that trademark owners will stop filing direct national applications. So obviously those trademark owners that have no connection to the Madrid system will still need to file directly, as well as those that are members of the Madrid system. It's their choice and it will remain their choice, and that their choice will depend on a number of factors. So, but what we've got to bear in mind is that there could be trademark holders that may not have considered protecting their mark in Trinidad and Tobago so far, but now they may do so because they may easily tick a box in their application form, in their international application form. So it makes it a quick, attractive, additional protection option, which they may not have considered before when they would have needed to file directly through representatives. It's clear that export companies in Trinidad and Tobago may benefit from the Madrid system. So let's look at where those companies are filing trademark applications. So these statistics refer to classes in applications filed overseas by Trinidad and Tobago companies and individuals. So this is a class count. This is not a number of filings, but rather the number of classes that have been filed. So in 2017 to 2019, companies and individuals in Trinidad and Tobago have filed for protection of their marks in 26 jurisdictions. 11 of those are Madrid members. So although you can see from this very colorful pie chart here that there are notably some high number of classes filed in 3 non-members, St. Vincent, Dominican Republic, and Barbados, there are significant numbers of classes being filed in Turkey, China, and the US, as well as decent numbers in Canada, the UK, Colombia, and the EU, with smaller numbers in ORP, Benelux, France, and Mexico. So this means that export-orientated companies now have the option to use the Madrid system to protect their marks in these countries, giving them an option that will give them easier access to their export markets and an efficient and a cost-effective means. A quick check on our global brands database also indicates that there are companies in Trinidad and Tobago, in Trinidad and Tobago filing in countries covered by the Madrid system. Here are just 2 examples, and you'll see that Blue Waters Products Limited filed in 5 countries, and 4 of which are Madrid members, and the Gili company has filed in many, many more. So that was a very brief presentation, and I just want to end on the infamous map that you've seen already and you may see again before the seminar finishes. But it's just to say that the Madrid system is always growing, and it's important that more and more countries are joining the system, making it even more attractive. So we are now working with several countries that we believe will be, or at least hope, will be exceeding this year in the coming years. And that will, of course, include Jamaica, United Emirates, and Chile. So this will make it even more attractive to trademark owners. So that's me finished. Thank you for listening.
Today, my colleague and I will be presenting the perspective of the IPO as it pertains to the Madrid system in Trinidad and Tobago. In our presentation, we will be looking at the declarations made by TNT, the TT IPO as an office of origin and as a designating contracting party. We will touch on the fees, we'll look at some of the statistics and measures undertaken by the TT IPO to implement the Madrid Protocol. So on October 12th, 2020, Trinidad and Tobago deposited the instrument of accession with WIPO, Director General, and the Madrid Protocol became operational on January 12, 2021. So in the picture there, you have Mr. Barman presenting the instrument of accession. And as at January 12th, the Madrid Union had 107 members. So you're seeing the coverage of members to the Madrid Protocol. So Trinidad and Tobago has chosen 4 declarations as part of its accession to the Madrid Protocol, which concerns the operation of the international registration system. So the first one being the extension of the refusal period to 18 months. So the extension from 12 to 18 months. So this means that a decision must be given before the end of the 18th month. So failing to do so would mean automatic protection of the international mark. The other declaration made by the TTIPO was individual fees. This was opted by Trinidad and Tobago. There are some jurisdictions that has the complementary and supplementary fee. And the individual fee has to be equivalent to the national fees. In our case, it is $1,400 for the first class and $150 for each additional class. The third declaration made was merger of divided international registration not provided for. So it is not afforded for or provided for under our national registration. So therefore, it is not provided for in our international regulations. And lastly, we have the declaration of intent to use the marker. As the TTIPO, we have a dual function. So we operate both as an office of origin as well as an office of a designating contracting party. So as an office of origin, we provide information to local companies, individuals, agents regarding the international application. We perform a certification. So this is ensuring that the particulars of the national application or registration, as the case may be, corresponds with the particulars of the international application. And lastly, we respond to irregularities that may be issued by WIPO. As it pertains to the DCP, we receive the designations, the IB, and we perform substantive search and examination to determine the scope of protection. Now, some more information as it pertains to the TTIPO as an office of origin. So I mentioned before, we certify the international application. You will see the citation of the relevant sections to the law. We do not have a processing fee. So there's no handling fee as it pertains to processing the international application. The filing language is in English. The office uses the current version of the NIST classification, and translation and or transliteration of the mark may be required as the case may be. So if it's a mark in a foreign language or it consists of foreign characters, then it will be a requirement. As a DCP now, the marks must be capable of being represented graphically. So this is pursuant to Section 3 of our Trademarks Act. And we mentioned before that we made a declaration of intent to use. So here we say the applicant must have an intention to use the mark in Trinidad and Tobago. This is also similar to as an office of origin. English translation and or transliteration of the mark may be required. In terms of representation of mark, there may be a requirement for additional representation, and this pertains to non-traditional marks. So say, for instance, a sound mark, we may require the graphic representation, so it must be capable of being represented graphically, and perhaps we may require, because it's a sound mark, maybe an MP3 file to assist the examiner in the process. Search and examination before the office. So we receive the application from the IB. We conduct searches for the rights of right holders. We examine both on absolute and relative grounds, and subsequent to publication of the mark, oppositions can be filed at the TTIPO prior to registration. Now, I mentioned absolute and relative grounds. So what does this mean? So absolute grounds is where the mark does not satisfy the definition of a trademark pursuant to Section 3 of the Trademark Act. So therefore, it is not distinctive, it is descriptive, it may be generic. With regard to relative grounds, we're referring to marks that are identical to goods or services for an earlier mark. So when we talk about it being similar, we're referring to the visual aspects, the oral or the conceptual similarity. As it pertains to responding to refusals under the Madrid Protocol, holders must appoint a local representative to respond to any refusal, and it must be done via the form TM1. And of course, the response must be submitted in English. Some of the notifications by the TTIPO. So we would notify the IB of a refusal. So it can be a provisional refusal. So we state the grounds of refusing the mark, whether it's under absolute or relative grounds. We may notify the IB of a refusal based on an opposition after the 18-month time, or we may do a refusal, a notification of a total refusal final decision. So apart from refusal, we would also notify the IB of statement of grounds. So this is where we accept the mark. So in addition to notifying the status of the mark in terms of accepting or refusing, right, we have to notify the IB. And then, of course, respond to irregularities. We would also notify the IB via the MOP, which is the Madrid office portal. At this point, I will ask my colleague to take over. This was touched on a bit earlier by Mr. Rubio in terms of the fees under the Madrid Protocol. So the fees are payable in Swiss francs. We are aware of that. In terms of the basic fee, it is 653. So this is regard to if the application is in black and white, and 903 if the mark is in color. I mentioned the individual fee before, 1,400 for one class and 150 for each additional class.
To continue on, so these are some of the trademark resources. All of these links can be on our TTIPO's website. You would have the Trademarks Act number 8 of 2015 and its accompanying regulations, the legal notice number 137, trademark regulations. This is with respect to our national regulations. You have the legal notice number 138. This is respect to our border enforcement regulations. And you have the legal notice number 290. This is our international registration regulations. All of these were in 2020. You can also find on our website information with respect to specifically the Madrid Protocol, and you can also find, of course, information on trademarks. This slide shows the applications specifically for the period of January 12th, 2020 to June 24th, 2020. And as mentioned before, as you can see, the percentage for non-resident applications outside of Trinidad and Tobago is 70%, and resident applications stood at 30%. Now, in comparison to this year, if you look at January 12, 2021 to June 24th, 2021, now, as mentioned, it became part of the Madrid Protocol system. So our applications have been split 3 ways now. So presently, as there was a decrease of the non-resident applications from 70% last year to 52% this year. There was, however, an increase of 1% to resident applications, and 17% of our applications were through the Madrid designations. So after many years of hard work by our controller, Mr. Ashgrali, and a lot of the members of staff at the TTIPO, we finally, as mentioned before, had our first filing for a Madrid application at the TTIPO in the name of Carnicon. This is a screenshot of our website itself. As you can see, if you go to our website and you go to the online services section, you go down to WIPO services, and then you click on Madrid Protocol. This will give you, as I mentioned, a lot of vital information you would need. And this is also a screenshot of what you would find on our website. So you will find the direct links to the Madrid application form from WIPO. You would also find all the Madrid forms that you would need with respect to any of your Madrid applications. The request to transform the application and to record a replacement of the application, those are 2 local forms, 2 Trinidad and Tobago forms. You would also find the Madrid fee calculator. This will give you a good preview of what the cost of your application will be. You can select your countries, you can see your cost, you can download it as a PDF. You would also see the Madrid booklet, which is a TTIPO booklet, and you will also get our Madrid regulations. On our website, you will also find the link for this webinar on the very detailed and excellent information that you can find in this booklet that was designed specifically for Trinidad and Tobago with the CarIPI project. You can find this link also available on our website in the Madrid section. So you've been hearing that we have been at this for many years. So there have been many initiatives, training initiatives for staff specifically at the TTIPO with respect to the Madrid system. So there was a study visit that was attended by my colleague Anelia and myself to the Madrid registry at WIPO. This gave you an on-hand experience of deal with applications at the International Bureau. There were also workshops for national offices on the operation of the system. There was a mission which was conducted in Trinidad by Mr. Neil Wilson of WIPO on the Madrid Protocol concerning the international registration of marks. There was another mission by Mr. Bakush, the project manager, Industrial Property Office, Business Solutions Division of WIPO. There was specific IPAS training, which is our database we use at the office, applications. And in November 2020, there was the first desk audit due to COVID that was conducted for the CTIPO, preceding the implementation of the Madrid Protocol in January 2021. So we had internal trainings and we also had external trainings. So there have been many public education initiatives by the TTIPO. To mention a few, there was one in January 29th, 2021, which was a workshop held by WIPO and Export TT on the Madrid Protocol. And it is also very vital to mention that Export TT is one of our bodies in Trinidad that provides financing facilities to companies. You can check the link and they will give you, and their website, and they will give you very detailed information in assisting you filing your application abroad financially. We also had 3 specific sessions with our Export TT body. We had a 2-day workshop, national workshop on intellectual property, and we had 2 this year. We had one in March, and we also had most recently one in April earlier. The TTIPO has been also involved in other sessions with specific mention of Madrid with some of our very important stakeholders. To mention a few, we do a lot of IP clinics with NEDCO, with MIHIS, CarIPI, Planting Seeds, and of course the University of the West Indies, which is our main national university. So this is just a little bit to give you an idea of the Madrid Protocol for setting units specifically. So it is cabinet appointed unit, and in 2014, cabinet agreed to the establishment of the unit and to allow the Intellectual Property Office to administer its obligations that would come upon accession to the Madrid Protocol. This is just to give you a small breakdown of the unit itself. So in the unit itself, we have trademark system specialists, which simply speaking, trademark examiners. And we do have a few trademark operations administrator and trademark operations officer. They are also examiners, but they more have specific emphasis of dealing with modification applications. And on behalf of my colleague and myself, this brings us to the end of our presentation, and we would like to thank you for your attention. We hope it was informative, and don't forget to check us out on all our social media platforms. Thank you.
I'm going to just have a quick run through as to what this Madrid Systems means for TT Fine Cocoa Company. Essentially, just to give you an overview, we are a relatively new company and only been established in 2016, but at the very core of what TT Fine Cocoa is about is to work with farmers to increase our output of our unique material in terms of Trinitaria cocoa, and to provide innovative new cocoa products and chocolate products produced in Trinidad and Tobago. Our core values are very straightforward in terms of sustainability and traceability, innovation, and promoting Trinitaria cocoa. It's specifically the promoting Trinitaria cocoa that I would like to put the context of where Madrid fits into this process. Essentially, we've all been faced with the challenges of COVID. It has changed and disrupted very much, but we've managed to use last year, 2020, as an opportunity to refocus our positioning. And one of the key things we realized, being dependent on hospitality, we had partnerships with Hilton and Hyatt hotels, with Caribbean Airlines, and of course, COVID stopped all of that. Very much as Khalil was saying with Carnival, these things stop us in our tracks, but we have to find new innovative ways to look ahead. And for us, what we have done in 2020 was to look at how we partner with other companies and other partnerships. And that's something that has led into the potential of now going from Trinidad out into the world. We, in 2017, we established a partnership with Harrods, and I mentioned a Hilton Hotel. But because of the COVID situation, Harrods, in fact, the department store in the UK, closed. Most of their staff, I'd say half of their staff, temporarily had to go on leave. And with the Hilton, we had very little traffic there. And similarly with the Hyatt. But for us, what we felt was that there was an opportunity to work with bigger brands and more of an international brand coverage. And why these partnerships are important is to allow us to find and identify new markets, not just in terms of how we partner with them, whether it's providing raw material or providing finished products, but it's also an introduction into the marketplace. And we've also been able to develop new ideas and concepts with other very well-established brands in Trinidad and overseas. For us, innovation is a key aspect of what we do. It's not just in terms of our cocoa and raw material, but it's also in terms of our products and what we can offer in the marketplace globally. So in 2020, when we worked with Angostura to look at the cocoa bitters, that was an enormous boost to the sector overall. It's something that allows farmers a sense of continuity with a demand, a product that's made from Trinidad and exported over the world. But also what we found is that with partnerships such as Nestle and even a brewery in the UK, we've been able to develop and innovate these products. And then really from that positioning, we understood there was a need to also protect our own positioning. And this is where Madrid is very, very important, to making sure that we have protection within our own brands getting out to those marketplaces. So intellectual property across a number of areas is key to TT Fine Cocoa Company. The key areas for us has really been around our products, our quality, and also creating partnerships, as I mentioned. So we've created a quality assurance logo ourselves, which allows third-party partnerships to use this, and that will entail that we will have the traceability and the quality assurance they need for the food standards, compliance, and also to inform their consumers about where the origin of the cocoa comes from. We've worked very closely with the TT IPO office on industrial design. We've spoken previously about trade dress and even GIs, but really the resource of the TT IPO office has been fantastic, and they've been a partner to us since the very beginning of this project in 2015. And then, of course, there's the joint branded initiatives. How do we get out there? And as I mentioned, with our partnerships with Harrods, it was the first time in 184 years that Harrods had actually put another brand, a different company, in co-branding a product there. So that was giving us the opportunity to then get the brand out. But it was also important that we protected that brand. So really, what happened? How does this work in terms of Madrid setting up a business, running a business, finding an opportunity, especially when things are moving during COVID? One thing we've learned in the past year is that there has been a shift in terms of how consumers use technology and how they engage directly with the origin of their products or service. So definitely the opportunity for storytelling brands has emerged exponentially in the past, I would say 18 months. There is also a very interesting trend towards larger corporations looking to work with these sorts of partnerships. And I'm certainly hoping, looking at Khalil's presentation, that Carnival also has the ability to take skilled, smaller groups of ideas, designers, and put them into a bigger audience. So really there is an opportunity where corporations, as I mentioned, a few of our partnerships are looking for that corporate social responsibility focus, with very much around livelihoods and environment. A key attribute for us has been the use of technology. And when we look at branding and we look at intellectual property, obviously, when you look at the power of Amazon and online e-commerce platforms, you cannot ignore it. So it was very important that we looked at this aspect of protecting our brand globally. And that is where we've looked at also our business model. So many businesses have suffered, has been affected by COVID. And it really was an opportunity to step back and really understand how do we protect our business models. And the protection of IP really does give a greater value to the overall business model. So this was very important for us. So without replicating what Mr. Rubio has said, there are a number of key benefits to Madrid, but I just want to allude to a number that for us with the TT Fine Cocoa Company, what is the most important benefit? And I really do believe that when you look at it, we are now in the game of storytellers. We are telling a story, whether it's a carnival story, whether it's a culinary story, whether it's a small bespoke manufacturing, cosmetics, it could be anything. That storytelling is important. And now you need to protect it. We've identified our key markets in terms of UK, Europe, China, and each country, as Mr. Rubio said, it has a cost. And when you're setting up a business, you don't want to incur that cost. So for us, what we want to do is to make sure that we target the right countries in the beginning, and we can add the additional countries as we go. Definitely the cost saving is there, but more importantly, I do feel that the benefit of it is to be able to have a one-stop shop process that allows us to get the protection and get us to market. I think for most businesses, when you're looking at an entrepreneurial start, a small-scale business, it really is important to protect. And that means that by protecting your intellectual property on these through the Madrid Protocol system, it allows us to enhance that business model. And that's important because this is a time when we will be going to banks and financiers, and they're going to want to see that, yes, you've got the idea, yes, you've got the resources, but have you protected it? So for me, one of the key things about this is to reduce risk of also infringement, but also to demonstrate that you have the mechanisms in place for protection. We're very excited by having the Madrid Protocol here. We're very excited by the engagement of the TTIP office and the support from the EU IPO office in getting this up. Now this is an opportunity to get this storytelling out. And for TT Fine Cocoa, the brand protects the storytelling experience. And it's a storytelling experience that protects the cocoa sector. And that's why for us, we really want to make sure that this is the tool in a similar way that can be leveraged in a way to protect not just the company, but our cocoa partners and the wider sector as a whole. So thank you very much for your time.
Well, in the next 18 minutes, I will explain how the Madrid system works using a real case involving a Spanish company related to cosmetics who wants to protect the name of its new cosmetic product. They want to sell this product not only in Europe, but also in different countries around the world. For this reason, we will be talking today about the following three aspects. The strategy to be used, the option of using the international system, and the advantages and disadvantages of using this system. Part of the strategy is to do the first filing as an European Union trademark, and in this real case, the application has been filed in January 2021, and later, and before the priority deadline, remember that it is 6 months from the filing date, they wish to file an international trademark designating Mexico, Colombia, Canada, Brazil, United States, and your country. Regarding the first point, the company ended up saving money as registering an international trademark is cheaper than registering the trademark in each individual country. In the end, they save more than 2,000 euros in official and professional fees. That is 35% of the total cost of this whole application. Again, if an applicant wishes to claim priority of an earlier filing, they must do so in the application. The UTM will normally be the basic application of the international registration. One of the most important aspects of the Madrid system, as my colleague already said, is the simplification of proceedings. For example, changes to an international registration that have effect in some or all the contracting parties concerned may occur during its lifetime. The main rule is that such changes, once recorded in the international register, will have a direct effect in the designated contracting parties concerned without the national or, in our case, a regional IP office having any say in this. Companies always think about expanding their international registration by including other countries into the registration, and this is called subsequent designation explained by Ernesto before, what means that the holder can add further contracting parties to their system, to their existing international registration, including new members of the Madrid system, without having to file a fresh international application. And this is, of course, in very, very often most that what people could think. The owner of the trademark can subsequently designate one or several contracting parties, and a subsequent designation may be made for all or only part of the goods and services recorded in the international register. Do not forget that the list of goods and services must remain within the scope of the international registration. In relation to declaration of use, there are some countries where you have to prove that the trademark is being used after a certain amount of years for the trademark to be still valid. In our case study, these countries would be the United States and Mexico. To prove the use of the trademark, you must file certain documentation, which will depend on each country, but the common documents are invoices, photos of the products and its packaging, website articles, etc. Just to give you an example, in the United States, you have to prove the use of the trademark between the 5th and the 6th year from the registration date, and then again at the time at the renewal. It was also mentioned by my colleague Ernesto Rubio that if you're going to designate the United States, the applicant must submit the an official form. It is the number MM18, and the declaration is required to be in English, regardless of the language in which the international designation is filed. Advantages, well, this is the last part of my presentation, and just to sum up, there are several advantages of using this system. Already explained by my colleagues before, but I'm going to repeat some concepts. First of all, if after filing a national or regional trademark application, you want to extend the protection of your trademark in third countries, the trademark owner can file only one international trademark application in one language and pay one fee before its national, or in our case here in Europe, our regional trademark office, instead of filing separately in the trademark offices of the different contracting parties in different language and paying a separate fee for each filing, and of course, in some cases, paying fees to your local associate in that country. Changes subsequent to registration, such as a change in the name or address of the owner, or a change total or partial in the ownership, or a limitation of the list of goods and or services, for example, because of coexistence agreement, may be recorded with effect for several designated contracting parties through a single simple procedural step and the payment of a single fee. And I think this is one of the most important aspects of the Madrid system. There is only one renewal date. But using the international system is not always beneficial. My colleagues talk about this. For example, if the home application of registration falls because it is rejected by the trademark office, or it is cancelled due to a revocation action, which would result in a central attack of the international registration, the Madrid Protocol provides for a limited period of time, 3 months, during which an international registration may be transformed into new national or regional applications in the designated contracted parties. Ernesto gave us some information saying that less than 4% of the basic applications are cancelled. But I just wanted to tell you that at the time you have your basic trademark cancelled and you need to transform your international applications in national applications, it could be quite expensive. On the other hand, once the international registration has been in effect for 5 years, it becomes independent from the basic registration. At that point, the possible cancellation of the basic application registration no longer has any effect on the international registration. And finally, if problems arise during examination or following the publication of an international framework application in a contracting party, for example, observations from the IP office or oppositions filed by the party, this may reduce or eliminate savings of professional fees if assistance from a local trademark agent is required. This is how we use the system when the basic trademark is the one registered before the EU IPO. But all explained during my presentation could be used in the same way if the basic trademark is a national mark from Trinidad and Tobago. For example, if you are a company from your country and you want to expand the protection of your national trademark in other countries, your company will have the same advantages mentioned before. And the proceedings are going to be more or less the same. But if you decide to designate the European Union in your international application, don't forget to indicate a second language of the UIPO which you accept as a possible language for opposition, revocation, or invalidity proceedings. Remember that you don't need to appoint a representative except in case there is a provisional refusal. Well, this is all I wanted to talk today. Thank you very much.